Honor's webinar on Florida automobile subrogation. This is our third in our series of webinars on automobile insurance subrogation. A few months ago, we had an initial 2-hour webinar in our continuing series entitled Automobile Insurance Subrogation in All 50 States, The View from 35,000 Feet. I'm Gary Wickert, and I gave the initial webinar, which was attended by over 600 clients and friends of Matthiesen, Wickert, and Lehrer, and covered the nuts and bolts of auto subrogation in all 50 states. A poll of attendees who were at that webinar, at the conclusion of the webinar, was taken, and the goal was to arrive at the top 10 states of interest with regard to auto subrogation. Texas finished first, so in April, I presented a webinar on Texas automobile subrogation. I'm licensed in Texas and Wisconsin, and I had practiced in Texas for 20 years. And that webinar was very well received with over 300 people in attendance, including about a dozen conference rooms. The recorded version of that webinar can be found on the Seminars Webinars page of our website, located at www.mwl-law.com. Florida, as you might guess by now, finished second in the poll. So in the following webinar, we're going to descend from 35,000 feet down to 1,000 feet and eventually land at Miami International Airport in Miami-Dade County. On the way, we'll be going into great detail on the many nuances of automobile insurance subrogation in the Sunshine State, all of the issues affecting subrogation which are treated in our new book, Automobile Insurance Subrogation in All 50 States, will be gone into for the state of Florida, on behalf of anybody who has automobile subrogation responsibilities down in Florida. So we're excited today. We have with us Alejandro Bautista, who is a senior associate with Matthiesen, Wickert, and Lehrer. Alejandro is licensed here in Wisconsin, and he is also licensed down in Florida, including the Eastern District Federal Court for Wisconsin. He practices all lines of national subrogation and civil litigation, including a large number of automobile claims in the state of Florida. With Alejandro's multiple licenses and his bilingual talent, he's an important resource for our firm's national subrogation practice, and as I think you'll see over the course of the next hour, he also knows quite a bit about subrogation in Florida and will provide you with some good information. Assisting us today is the law firm of Brummagem and Rathett. Brooks Rathett is our local counsel down in Florida, and he practices in litigation, specializing in the in subrogation, insurance litigation, and complex commercial litigation. His practice includes the representation of many major automobile carriers, both in recreational vehicle manufacturers and large insurance companies across the country. He has been the lead or sole counsel in numerous jury trials and has received several zero-damage defense verdicts and many multi-million-dollar plaintiff's verdicts. And he's recovered attorney's fees in several cases and appeared before the Florida District Courts of Appeals and has prepared appellate briefs on in a number of jurisdictions. He is licensed in Florida, Georgia, New York, and the District of Columbia, and is also a certified mediator for the Florida Bar. So today, as we get into the third of our series in the second state of Florida, we'll be looking at automobile insurance subrogation. The fact that Florida is a no-fault state, of course, provides some complication. PIP subrogation becomes complicated in Florida, complicated by several statutory exceptions and a pesky collateral source rule that Alejandro and Brooks will go into in some detail. Before I introduce the two of them, I'd like to just remind you that the next automobile insurance subrogation webinar in this series will be on the state of California, which finished third in our poll, followed by New York, Illinois, Colorado, New Jersey, and so on down the list. The date for our next webinar has not yet been scheduled, so keep an eye on our website and newsletters for more information on the next automobile subrogation webinar. So at this point, I'd like to turn the steering wheel over to Alejandro Bautista, who will get into some of the details on Florida automobile insurance subrogation. Alejandro?
Well, good morning, and thank you, Gary, for that introduction. As Gary mentioned, my name is Alejandro Batista, and I am joined today by Brooks Rathett. Together we're going to present the Florida Automobile Subrogation webinar. And we have many topics to cover today, so we'll go ahead and jump right into it. Before we do that, I'd like to mention that at the end we will have some time, or we should have some time for questions that we'll try to pick out some and answer for you. And we also have a trivia question for participants. The first to email or send the answer to the question via the tool here, the question tool, will receive a free copy of our automobile subrogation book. So to start with, the state of subrogation in Florida. Florida is a strong subrogation state with with 15,507,284 licensed drivers, up to 24% of which are uninsured, and this is top 5 in the nation. The state does recognize both contractual and equitable subrogation rights, the right to reimbursement as well, and intervention is not automatic in Florida. It is left to the discretion of the trial judge. The decision to permit intervention by a carrier is based on specific facts of the case and whether or not the court has taken efforts to protect the subrogation rights. MedPay subrogation is allowed. PIP subrogation is not allowed, and the made-whole rule is recognized but can be overwritten by the plan language, and we'll get into specifically these last 3 points in some more detail. We'll start by quickly running through the types of automobile coverage in Florida. First, the mandatory insurance requirements. Florida's motor vehicle no-fault law sets forth these mandatory requirements, and they apply to owners with a valid license plate that are looking to purchase or renew a state license and registration. And anyone living in Florida for 90 days in a 365-day period. And now these 90 days are total. They do not need to be consecutive. The 2 types of mandatory insurance requirements are personal injury protection, PIP coverage, and property damage liability coverage, both of which are discussed in the coming slides. But before we get into the 2 types of mandatory coverage, I'd like to discuss briefly bodily injury liability automobile insurance in Florida. This type of coverage is not required. In fact, Florida is one of only 2 states that does not require it, the other one being New Hampshire. There is an exception, though, if a person has been convicted of driving under the influence, then they are required to obtain this type of coverage. If the conviction occurred on or before October 1st, 2007, then the minimum coverage is $10,000 per person and $20,000 per accident. After October 1st of 2007, if the conviction is after that date, the minimum coverage is $100,000 per person and $300,000 per accident. That convicted driver must maintain this coverage for 3 years following the return of the driver's driving privileges. Also important to note, Florida has the financial responsibility law. This law requires an at-fault driver who has been deemed responsible for an auto accident resulting in bodily injury or personal property damage to others to have full auto liability insurance coverage. That is bodily injury liability coverage, the minimum being $10,000 per accident, per person, and $20,000 per accident. And property damage liability coverage with a minimum of $20,000 in coverage. So back to the mandatory types of coverage. The first one we'll discuss is PIP coverage. It is, again, the first of the two mandatory required coverage types. It is part of the no-fault coverage system. The minimum is $10,000 of coverage, and PIP pays for 80% of the insured's reasonable and necessary medical expenses, 60% of the insured's lost wages and reasonable expenses for replacement services, and $5,000 in death benefits. This is without regard to fault. Property damage liability coverage, the second form of mandatory coverage, the state requires a minimum of $10,000 of coverage. It pays for damage or destruction of the property of others. Some of the optional insurance coverages, the types here: bodily injury liability coverage, uninsured and underinsured vehicle coverage, collision coverage, and then medical payments coverage. Oh, and I went too quickly there. The first, bodily injury liability coverage. Again, it's optional for most of the residents of Florida. The exception being, as we just discussed, it is required for drivers convicted of driving under the influence. The minimum bodily injury liability coverage is $10,000 per person, $20,000 per accident. Coverage pays for the insured's potential legal liability following serious and permanent injury or death to others, and the legal representation if litigation should be necessary. Uninsured and underinsured motorist coverage. This again is optional. It pays for the negligent defendant who illegally does not have liability coverage or has a minimum coverage that is inadequate to fully compensate the insured for the injuries. It is required to be offered to an insured, but it can be rejected in writing. And the minimum limits of the UM coverage must be equal to the BI coverage unless the insured selects lower limits. Collision coverage, again optional. It pays for repair or replacement of the insured's vehicle regardless of fault. So you have a situation in Florida where an innocent victim of an accident can present a claim for property damage under their own collision coverage or under the negligent defendant's property damage liability coverage. Your collision coverage typically includes a deductible where property damage liability insurance coverage obviously would not. I'll take a moment here to point out, because we don't have a separate slide on this topic, Florida does allow and recognize property damage subrogation claims based on both equitable and contractual rights. The carrier is entitled to recover the difference between the value of the vehicle before the accident and the value of the vehicle after the accident, or, and this is at the carrier's election, the reasonable cost of repair or restoration of the vehicle with allowance for the difference in the value. So again, I just wanted to take a moment to mention that. Finally, the last form of optional coverage that we'll discuss is MedPay coverage. It pays for the reasonable or reasonable and necessary medical expenses, those not covered by PIP, the 80% that PIP covers. It is governed by the terms of the policy. So with that being said, we'll go ahead and move into the types of automobile subrogation in Florida, starting with MedPay subrogation. A policy containing MedPay coverage may contain subrogation and reimbursement terms related to these benefits. MedPay is considered a collateral source under the state's collateral source rule, which is as listed there, section 768.67 of the Florida statutes. It means that they can be subrogated. The case law clearly indicates that MedPay benefits can be subrogated. Also, with regards to MedPay subrogation and reimbursement, a MedPay carrier has a right to be reimbursed against the owner or insurer of a commercial vehicle if benefits paid resulted from the insured having been an occupant of the commercial vehicle or having been struck by the commercial vehicle. Additionally, MedPay benefits paid to one who is injured in the course and scope of that person's employment and who is covered by workers' compensation insurance, those MedPay benefits are recoverable from the work comp carrier. PIP subrogation. PIP benefits may not be subrogated. The PIP coverage is governed by section 627.736 sub 3. However, similar to the MedPay carrier, a PIP carrier has a right to reimbursement against the owner or insurer of a commercial vehicle if the PIP benefits paid resulted from the insured having been an occupant of the commercial vehicle or having been struck by the commercial vehicle. Also, just like MedPay benefits, PIP benefits paid to one insured in the course and scope of employment and covered by workers' compensation insurance are recoverable from the workers' compensation carrier. Uninsured and underinsured motorist subrogation. A UM carrier has a right to subrogation against the uninsured or underinsured motorist. This is a common law equitable right to subrogation against the UM. It is not considered a collateral source. Section 627.727 sub 6 governs UM subrogation, and it sets out the requirements of the parties. First, the insured who's intending to seek UM benefits must notify the UM carrier when settling the case. The UM carrier then has 30 days from receipt of the notice to either agree to the settlement, waiving the rights of subrogation against the tortfeasor, or make a substituted payment in the amount of the tortfeasor's offer in settlement of the claim, and thereby preserving subrogation rights against the tortfeasor. A UM carrier's failure to properly respond within the 30 days results in a waiver of its subrogation rights. The UM carrier with a subrogation right may file its own subrogation action within the applicable statute of limitations, or may intervene into the insured's third-party case even after the statute of limitations has run. So with the above being said, the question of when a UM carrier can initiate a subrogation action after paying its insured the amount that was being offered by the tortfeasor was addressed in the case of Metropolitan Casualty Insurance Company versus Tepper. The Florida statute states that upon final resolution of the UIM claim, the UIM insurer is entitled to seek subrogation against the UIM and the liability insurer for the amounts paid to the injured party. There had been some conflict between Florida courts as to whether this meant the carrier could initiate the subrogation action as soon as it paid the amount offered by the tortfeasor, or whether it had to wait until the insured's claim was finalized. The court held here that final resolution of the entire claim was a condition precedent to the carrier's entitlement to bring the subrogation action. The court also said that the statute of limitations does not begin to run until the entire underlying claim has concluded. Obviously, this is meant to avoid prejudice to the carrier. Therefore, the finalization of the entire claim is necessary before carrier may bring the subrogation action. And then before I turn it over to Brooks here, I have two doctrines here that I'm going to discuss, and then one final slide, and then I'll go ahead and let Brooks take over. First is the made whole doctrine. This is recognized in Florida. Florida says that an insured does not have a common law right to subrogation or reimbursement against the tortfeasor unless the insured has collected all of his or her damages and has been made whole. Where an insured is made whole, the payments over and above the actual damages may be viewed as a double recovery, entitling the carrier to subrogation reimbursement rights. The doctrine can be overridden by contract, and it is not applicable if the insured disregards the carrier's subrogation rights by settling for less than the policy limits or by releasing the tortfeasor from all claims. Second is the common fund doctrine, also recognized in Florida, and it states that a successful subrogated carrier will be required to share in reasonable costs of litigation, including attorney's fees. It is not applicable where there is substantial assistance by the insurer to the insured in connection with the underlying litigation. That comes from that Tampa Port Authority case. Substantial assistance is equal to active participation, essentially direct intervention in a joint representation of the insured's third-party case. If there is substantial assistance, then no attorney's fees or costs are to be deducted before the subrogated interest is repaid to the insured.
Thank you, Alejandro.
I have yeah, one more slide that
sorry.
Again, my quick fingers here just forwarded one slide too quickly. Statute of limitations, I'd just like to list. A tort claim for personal injury or property damage is 4 years, a wrongful death claim 2 years, and medical or dental malpractice is 2 years from the date of the incident or occurrence, or when that was discovered or should have been discovered, but in no case is it going to be later than 4 years. And so with that, I will go ahead and turn the presentation over to Brooks.
Now I'll say thank you, Alejandro. The first topic I'm going to talk about ties in a little bit to the made whole doctrine that you talked about. And it's in the area where you have to be careful in handling these cases to know what is going on with the insured if they are in a lawsuit of their own. If they have filed a lawsuit and you are trying to intervene or have a subrogation case, if there's a lawsuit for excess damages and perhaps the insured has been made whole by the insurer, but they are trying to settle their case. And what could happen, the risk here, is that if the insured enters into a release and it's executed with the third party, that could cut off the insurer's subrogation rights. Now, there are a couple things that can protect the insurer here. Number one is there's a contractual issue. The insurance policy itself might say that there's a duty to cooperate, and that this could be a breach of the duty to cooperate, which could create some type of action there. But the other thing is that subrogation in Florida is considered generally not a contract issue, but an equity issue, an issue of fairness. So it would be unfair to allow the insured to do that, to settle without the insurer having a chance to recoup or recover. And so the key thing here is that if the insured has knowledge that there's a subrogation claim, then it would be void. The entry into the settlement would be void from all the parties that are participating when they have knowledge. But even more protective for the insurer is that if there's constructive knowledge, if the party has actual knowledge of the facts and circumstances, that would lead a reasonable person to inquire and discover the fact that there's a subrogation claim, and this includes all the parties involved, then that would perhaps protect that risk that it would destroy the insurer's subrogation rights. The next slide I have here is coming up here. See if I can get that here. Alejandro, are you able to forward the next one? There you go. Thank you. I'm just having a little trouble. The reimbursement of the insured's deductible. So here's the question, again, ties into this made-whole doctrine. Generally, the made-whole doctrine can only be used as an affirmative defense by the insureds, those people insured, to protect their direct recovery from the third party, so that they have to be made whole before the insurance company be entitled to any more proceeds. But what about the deductible? Well, it's pro rata shares is the policy in Florida. So, for instance, an automobile insurer will not be held to have violated the made whole doctrine, where it returns to a comparatively negligent insured a properly calculated pro rata portion of the deductible. So if the insured was partially at fault and therefore has some percentage of fault involved in the underlying accident, then to be made whole, they don't get their entire deductible back. They only get a pro rata share of it. So that ties into the next topic, which is the comparative fault. Florida, you may have heard in other states terms like contributory negligence and comparative negligence, comparative fault. Florida is what's called a pure, or known as a pure comparative negligence or comparative fault state, and therefore it's also a comparative subrogation state. What this means is that in a non-subrogation context, even if you are 99% responsible for an accident, you could still sue and go to court to recover the damages attributable to the 1% of someone else's fault. And the recovery, of course, is reduced by your degree of fault. So in a $10,000 case, if the plaintiff's $40,000 or 40% at fault, they would recover $6,000 of the $10,000. 6,000, 60%, 4,000, 40%. Same thing in subrogation. So subrogation can be pursued as long as there is some percentage of liability that can be placed on the third-party tortfeasor, as long as there's someone else to blame other than the insured for the accident or for the damages. And the statute, just to point out, the comparative fault statute in Florida is 768.81, subparagraph 2, and that talks about third-party and those types of things. Now, the next doctrine we'll talk about is the sudden emergency doctrine. What does that mean? These are doctrines that involve accidents, typically, and they are defenses or when someone attempts to say, look, we're not responsible and here's why. And the sudden emergency doctrine is one of those. The rule is when someone is confronted with a sudden and an unexpected danger, they're only required to exercise the judgment that an ordinary person would under those extraordinary circumstances. So think about this. Typically, it's ordinary care. You're supposed to do what an ordinary person would do. If you're involved in a sudden emergency, does that get you completely off the hook? Are you allowed to do anything? No, not necessarily. It's still a reasonable person standard, but it's a reasonable person in that situation, that emergency situation. So, for instance, running a red light to avoid another car, is that okay? You're doing something wrong. You're running a red light, but you're doing it to avoid another car. Would someone else have done that, or would they have slowed down and pulled over? Those are issues of fact, and they would probably questions of fact that would go to a jury. And the other important factor is if you create the emergency, if you're the reason for the emergency, and then you act based on that emergency, you don't get that benefit of the doubt there because you created the emergency. So that's the sudden emergency doctrine, which could tie into the next one. If there is an accident, we get into the seatbelt defense in Florida. And this is a topical issue. There's been recent District Court of Appeal appellate law in Florida as recently as last year on this issue. And what the seatbelt defense does is it allows the defendant in the car accident, the person being sued in the car accident, can try to shift blame to a plaintiff who is not using their seatbelt at the time of the accident because, yeah, maybe the accident might have been the defendant's fault to some extent, but the damages, the injuries to the person suing certainly can be exacerbated by the lack of a seatbelt. So there's a seatbelt law in Florida that there's a requirement that passengers in the front seat must wear a seatbelt. Of course, the driver must wear a seatbelt. And passengers under 18 have to be properly belted or in child safety seats. Now, the key here is that the person moving for the seatbelt defense, the defendant that says, look, that plaintiff wasn't wearing a seatbelt defense, still has to get expert testimony. And this is the recent case law. They still have to come up with expert testimony that it was a failure to use the seatbelt that was the cause of the injury complained of. There has to be some connection, some causal connection. It's not a strict liability type of defense where you didn't have your seatbelt on, therefore you can't sue me and you can't win. It is instead, you didn't have your seatbelt on, and the injuries you're complaining about, the fact that you hurt your back or that you smashed the front of your face, is because you didn't wear a seatbelt, and I should not have to pay for those damages or be responsible for those damages. So that's the seatbelt defense. The next issue we have is negligent entrustment, and now we're getting to issues where we're already in the area of subrogation where we have third parties. Now with negligent entrustment, we might have all sorts of people involved that might not own the vehicle at issue, but were involved in the accident. And what you might have heard this term also called a dangerous instrumentality doctrine. The concept is when you have something that's considered a dangerous instrumentality, an automobile, a perfect example, and certainly in Florida it is considered one, and you entrust it to someone else, you could do so negligently. If that person gets in an accident, you could be responsible, or the party could be responsible for entrusting it to someone else. And the dangerous instrumentality in Florida imposes strict vicarious liability when the owner of the vehicle voluntarily entrusts it to an individual whose negligent operation caused damage to another. You almost have to think of it as though the owner was the one in the vehicle that was negligent. That's what that means, that vicarious liability and that strict liability aspect is they put the owner in the seat of the person who was negligent. And this goes way back in Florida. This concept, it's a very old concept, but it continues to this day, and there's updated case law. But we put the basic premise up there is that Florida Supreme Court case all the way back from 1920, that if you, the owner, negligently entrust the vehicle, you assume the responsibility. You could be responsible even though you were not driving, and you try to make the argument you were not responsible. The next concept ties into this a little bit is in some states there is a guest statute, a law about guests, that what it does is Florida doesn't have this. Florida does not have a guest statute that prevents passengers from recovering money damages from the driver or owner of the vehicle in the event of an accident. In Florida, you could, a passenger can recover money or damages from the driver or owner of the vehicle. In Florida, the injured passenger does have a right to seek compensation from the driver owner. So again, you've got another possible party, possible target. All these issues are when you're trying to analyze a case and decide who can we sue, who can we recover from, who has to be made whole, who's been made whole, who's settling this or negotiating this, who's involved, basically. You could have a passenger, a relative involved that's as well, passenger or relative or both, involved in the accident, and they can sue the driver or owner in Florida. The next concept in Florida is called the economic loss doctrine or economic loss rule. I've seen more often now lately in the case law, they're calling it the economic loss rule. But if you see either one, it's the same concept. And it follows the majority rule throughout the United States, most of the states that I've seen. And what that means is, typically in our cases, you're suing for negligence. You're suing for tort theory, a wrong. Someone has done something wrong. What the economic loss doctrine says is that if you are in a contract, if there's a contractual relationship, for instance, a good example of this is if there's a warranty that the car will be repaired by a dealership. Dealership warrants that it's going to repair the car. And if the car is damaged, but because of the breach of warranty, breach of contract, because the dealer didn't fix it under the contract, but if the only damage to that car is to the car itself, not to any personal injury, not to any other property, then the only cause of action one would have would be under contractual theories, under a breach of warranty or a contract-like theory. You cannot sue in Florida for negligence, for strict liability negligent design, negligent things like that, without a personal injury or injury to separate property. And what I mean by injury to separate property is an example of that would be, let's say the dealer did not fix the car properly and it caught on fire. You're not going to be able to sue over the car. But if that fire spread and burned down the house, then you could get out of the economic loss doctrine. That's where you have to determine whether you're dealing with a contract case or a tort case. The next issue are multiple claims in excess of liability. Now, there's kind of a split in authority in Florida about this for the duties of the liability insurer, whether or not they have to pay out if there are multiple claims and they exceed liability. So in the one case we cite, the Florida case of Farnas versus Florida Farm, an insurer should not exhaust its available policy proceeds. It shouldn't exhaust all of its proceeds without an attempt to settle as many claims as possible. So if there are multiple claims, that case is basically saying don't exhaust all of them on one and then have nothing left over for the others. And now a federal case, the second case below that is federal court applying Florida law or interpreting Florida law. And they look at the facts and they applied Farnas, but they said under the circumstances of their facts, the insurer was entitled to summary judgment because the insurer acted reasonably and in good faith where it didn't know about other survivors or didn't have the information it needed to hold back on settling with the first claimant. So it tends to suggest there can be a fact issue. The key to this is with everything involving, of course, insurance payments is you have to act in good faith to your insured when settling with third parties. That's the key language in Farnas and in even that federal case. Florida Supreme Court has yet to address this issue, so it's still kind of an open question, and it's hard to answer tell you what the answer is. I mean, good faith is the guideline. The next issue we have is DRAM shop liability, kind of an old-fashioned term. What we're talking about are bars and liquor stores and restaurants that serve alcohol. And this is another type of defense out there or type of claim, works on both sides, that what the statute, there's a specific statute in Florida, and it's section 785.125. And what it does is it exempts vendors of alcohol, bars, restaurants, liquor stores, from liability for the injuries caused by people who get drunk or intoxicated, impaired through alcohol. But there are exceptions to that rule. They're pretty narrow exceptions. They're pretty extreme exceptions, but they're exceptions nonetheless. So again, good investigation. Yeah, it calls for asking the right questions and figuring it out. But if one of these DRAM shops or liquor stores, people selling alcohol, willfully and unlawfully sells alcohol to a person underage, they could be held responsible for that. That's a violation of other statutes and criminal sanctions as well in some places. So that's one way there's an exception. And the other is serving alcohol to a person habitually addicted to alcohol. Now that might not seem like it's common, but they might have the kind of relationship with the customer or with the patron that they know this person is habitually addicted to alcohol and they serve them anyway, then they could be negligent. Now there's an exception to the exception, which is a fake ID defense, that if one of these proprietors sells alcohol to someone underage, but they show that there was a fake ID and they were reasonably tricked by the fake ID, they can get out of DRAM shop liability exception. So things to take away: generally not liable, could be liable, but there's an exception even to that. The next one is whether or not you can get attorney's fees in Florida in cases where you sue or are sued. And you can get them in both cases. Obviously, typically you can only get attorney's fees if it's statutory. There's some kind of statute that says this statute allows for the award of attorney's fees, or if it's in a contractual relationship, if the contract says the prevailing party gets attorney's fees. Florida, though, there's another method, and it's called the proposal for settlement / offer of judgment. The proposal for settlement is procedural. It's Rule 1.442. The offer of judgment is statutory. It's 768.79. They both work together, and you must follow the procedures under 1.442 if you're going to try to make an offer of judgment. You must follow these procedures, and they are strict. Florida is nitpicky about these standards, and if you don't meet them, your proposal will likely be stricken later in time. So this is a very important thing. And what is it? What it basically is you're offering to settle the case ahead of time. You're trying to resolve it in a formal manner. And if you're the plaintiff, you offer a certain amount to settle. You say, I will take X amount of money to settle this. And if you end up, if it's rejected, you end up going all the way to trial, you end up getting a judgment in an amount that's at least 25% more than what you offered, then you can get your attorney's fees. And think about that. Think about the rationale behind that is, you, the plaintiff, tried to sue for about what the case was worth, and the defendant said no. You went all the way to trial, and you proved the case was worth more than what you offered, 25% more, then you get fees. On the flip side, if you're the defendant and you try to settle it, and you say, look, we will offer to get out of this case right now for this amount of money, and you go all the way to trial, and the plaintiff does not get at least 75% of what you offered. Basically, if they do worse than they would have done, 25% worse or more than they would have done taking your offer, then the plaintiff's on the hook for attorney's fees, and they have to pay the defendant's attorney's fees. So that's an important strategy to think about, because it changes the dynamic of damages dramatically. You could be talking a lot more damages than you thought you were. That's it for that category, and I think that's it for my slides.
Okay, well, that is the conclusion of our presentation. We do have some time here for some questions, and Brooks, I've pulled here one, maybe two that I can get to if you want to take a look at for some. I'll go ahead and answer this first one.
Okay, go ahead.
So the question here, is a plaintiff's attorney required to provide notice of a carrier, a notice of filing suit? The answer here is if it's a collateral source under the state's collateral source rule, which is section 768.67, the statute has specific notice requirements. Under the statute, a plaintiff's attorney, or if no attorney, then the claimant, is required to provide notice to the carrier of the claimant's intent to claim damages from the tortfeasor by certified or registered mail. If a complaint has already been filed, then a copy of that complaint should be sent along with the notice. The notice must include a statement that the carrier is it will waive its right to subrogation or reimbursement if the carrier does not provide notice that it is asserting its rights within 30 days of receipt of that notice. Brooks, do you have one?
I have one here that asks whether an insurer can seek subrogation in Florida if the insured does not move to intervene in the underlying action between the insured and the third party. And that's a good question, because procedurally that's a decision to make, is does the insurer want to make a motion to the court, move to intervene in the actual lawsuit, and although you're not technically a participant in the lawsuit because you kind of stand in the shoes of the insured, you are more engaged as an intervener than you are as a non-intervener. Well, the short answer is yes, you can seek subrogation without intervention, without being an intervener. However, from a practical standpoint, intervention might be the best course of action to take. And what I'm talking about here also is, remember that this is an ongoing underlying lawsuit with the insured. The insured suing for damages perhaps in excess of what they received from the insurance company. So they've got a lawsuit going on. And at the same time, you want to seek your subrogation rights. So you want to intervene in their lawsuit. And it might be a good course of action because it avoids confusion about the insurer's rights. No one can claim when they settle the case, we had no idea that the insurer had any rights. You've intervened, or you've moved to intervene, so you've certainly made everybody aware, every party. But a subrogated insurer is not required to intervene in a pending tort action to preserve its rights. It can, it's not required to, but in most cases it might be recommended.
Okay, I have another one here. This question asks, does a personal injury attorney have to resolve a subrogation claim? Also, as a subpart to that, if not, whose duty is it to resolve a subrogation claim after a verdict or settlement? Actually, the Supreme Court of Florida recently, and this was in April of 2012, issued an opinion answering this question. This was an opinion where the Supreme Court was discussing a proposed change to the Florida Bar rules concerning fees and costs. The citation is SC 10-1967. In the opinion, the Supreme Court makes clear that lawyers representing plaintiffs in personal injury, wrongful death, or other cases where contingency fees, where they're charging contingency fees, should, as part of the representation, also represent the plaintiff in resolving medical liens and subrogation claims related to the underlying case. So in essence, a personal injury attorney does have the responsibility to resolve any sort of subrogation claim or reimbursement claim.
Okay. I had a question, and perhaps I didn't explain it carefully enough on the sudden emergency doctrine. The question is, what would prevent anyone involved in an accident from just claiming, there was a sudden emergency and getting out of it? Well, I tried to mention, I think I did, again, it's a question of fact. It's going to almost always be a question of fact. And the same types of questions that are asked about who caused the accident would have to be answered with respect to what was this so-called sudden emergency and what created it and how was the person responding to it. And there has been some fairly recent case law in Florida, and there are some elements to proving that there was a certain sudden emergency that caused the driver to act the way the driver acted. One is you have to show that an emergency actually or apparently existed, that you were swerving to avoid another car, you were swerving to avoid a person in the street, you were going to get, hurt more people if you didn't, drive off the road, and then that's why you hit somebody's property, something like that. So you have to show that that emergency actually existed. Same kind of evidence you would use to show the accident itself. And then, again, that it wasn't caused by the person claiming it, that you didn't fall asleep at the wheel or were impaired in some other way or just not paying attention or were speeding, something like that. And then the other issue, there's another that alternative courses of action to meet the emergency, were they open to you? So it gets really complicated here. It gets kind of, you're parsing a lot here, but if there was a much safer course of action other than the emergency, I mean, other than running the red light, could you have come to a complete stop ahead of time? Could you have gone off the road but onto the shoulder instead of across the, median or something? I mean, you have to show that the course of action that you took was the one, you felt you had to take. And then finally, again, this is where that reasonable person is, and this is where jury's going to come in. You're going to ask. In Florida, it's 6 people, by the way, 6 jurors, generally speaking. You probably, in some states, are familiar with maybe 12 jurors. Florida, in a civil case, you're going to have 6 jurors, and you're going to have to prove to these folks that someone in your situation or the driver's situation would have done the same thing, would have acted the same way in a similar situation, would have done in a prudent way.
Okay, I think we are right up against the clock for more questions. If you have any additional questions, please feel free to send them our way. We obviously did not get to all of your questions right now, but we will get back to you via email. Before we end, as promised earlier, we have a trivia question for everybody. Again, the first person to respond with the correct answer will receive a copy of our auto subrogation book. The question is as follows. In March of 2012, as a result of its no-fault studies, Florida passed a new law which caps non-emergency medical condition PIP payouts to $2,500, limits the time to seek medical treatment following an auto accident to 14 days, and excludes massage therapists and acupuncturists from the medical providers covered by PIP. The question is, what is the House Bill number of this new law? First person to answer correctly will get a copy of the book. We'd like to thank you for joining us today. And again, please look out for our newsletter and an announcement of our next subrogation, automobile subrogation, which will, of course, cover the state of California. Thank you.